This is so wrong of the prosecution. What you were told is wrong, and this lawyer knows it because she sat here in court and I did the same thing without being tempered.
So you are telling me you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
The Young Thug YSL RICO trial has resumed with important motions being argued and ruled on by Judge Whitaker. A lot of motions today. This video is probably extremely long. Miss Love and Judge Whitaker are already starting a little bit of a beef here because Miss Love is wrong in this situation. You'll see what happens. Hit subscribe, join the channel membership. Love you guys. Here we go. So it looks like Thug picked this suit. Remember, he's only allowed to have like 5 suits now.
Filed by the state essentially for a gag order on the defense.
Ooh, we're starting off with bullshit demand from the state for the defense lawyers not to speak to the media, which is just insane.
I've read the motions. I've read the responses. If a response was filed, I have read any replies that got filed.
Other instances similar to in nature to the ones that we pointed out to the court have occurred.
Oh no, they've talked to the media more. It's in the public domain. They're allowed to do it.
We will stand on our response, unconstitutionality and issues with gag orders as prior restraint. That case is with respect to the news media, but there is some analogous language in that, and I'd just like to point the court to that. Thank you.
All right, thank you. But I think that in regard to the propriety of doing that in this case at this time, I'm going to deny the state's motion.
The right ruling. Defense lawyers have the right to speak to the media. So this is the motion where Brian Steele basically challenged to make it part of the official record that the ex parte meeting was improper. The legendary Brian Steele is about to speak, boys.
The Honorable Judge Krause found in her result, we don't take offense to, or we agree with actually, but some comments which were that ex parte meeting might have been, I'm not looking at her order, might have been okay if it was done in open court. I strongly, and Mr. Adams strongly disagree with. And the reasons are in the joint affidavit.
There's Shannon Stillwell, one of the alleged shooters in the Donovan Thomas murder.
Somehow, according to the transcript, the ex parte hearing transcript, June 10th, 2024, there's the recused judge, Ms. Love, Ms. Bumpkus.
Let me interrupt you for just a second. I've read the entirety of that ex parte transcript, so I'm familiar with what happened in that.
All right, so she's done some work. She said she was going to catch up on the case, but
nothing there was good. Everything was wrong. And I believe there was intimidation put upon the witness to change his statement. He made it very clear to send me back to the DeKalb County Jail. I'm not testifying. I find that the trial judge's efforts to persuade the witness to testify went too far. The authority to initiate contempt proceedings, however, is not a license to intimidate a witness into testifying.
This is a good case for them to cite because it's basically showing that the correlation where in the Thug trial, the judge went too far, and in this Maryland trial, the judge went too far.
It's hard to find a case like ours, but I searched and I found this. And what happened here, as the court is aware, the witness said, can I have 2 weeks to go home on house arrest instead of in the county jail? His child was having a birthday. That was a big deal to him. That answer to that question was done by Ms. Hylton in front of the judge. Ms. Hylton said, no, you cannot, you have to go to jail.
Yikes. I still can't believe they think this meeting was proper.
Mr. Copeland said in that meeting, everything I said was a lie. I've never told the truth in my life until this statement right now. That is like bullseye of Brady. It was hidden from us. It came out later, but it was attempted to be hidden.
All right, so that's in the context of another motion of yours, right? So let's focus on this motion for now.
My point is, nothing was done appropriate. I mean, and I don't want to get into it, and the state actually filed a motion later saying, the Honorable Judge Krause already ruled on this. I didn't know that they would do that, but I already said, I'm not accepting those factual findings, respectfully, because they're wrong, A, and B, they weren't even needed for the finding. Another issue that came up is Mr. Copeland was told how to testify. I don't know how this happened because I don't have the question. But Judge Glanville told the state in front of Mr. Copeland and his lawyer, didn't you give Mr. Copeland the state's questions that they're going to ask him? I don't have those questions. The judge said to Mr. Copeland, remember what Ms. Love told you. Unless you tell a big whopper of a lie, these are not quotes, you're not going to get in trouble. That's not in the transcript. So something happened outside the transcript. Those are just a few issues. There are more. They're all in our affidavit. But those are a few issues that when Judge Krause said everything that was done, if it was done in open court, was appropriate, everything that was done is intimidating a witness. And it changes the complexity of the case because what you will find out is Kenneth Copeland, these are my words, made misstatements to law enforcement. He made 6 statements. They're all audio, video recorded except for 2. They track over 16 hours. The judge told him and Ms. Hylton told him. And Mr. Copeland said, you previously told me, meaning Ms. Hylton, I could just say I don't remember, I don't recall. And the judge said, yeah, you won't get in trouble for that. Well, what that does is under Georgia law is that triggers a prior inconsistent statement, which is all that the state wants him. Mr. Copeland is just here for his prior consistent or inconsistent statements. And that's what happened in the Archer case. That's why they're saying the judge said to Mr. Bailey, you can even testify for Mr. Archer. You won't get in trouble because, and it explains in the Maryland case, because that would trigger and open the door to prior statements, which is all the state wanted. As found by the Maryland court, this is intimidation. There was nothing appropriate. And the Honorable Judge Krause, I'm confident, did not have this case, but I respectfully disagree. And that's why I wrote that motion.
All right.
I may say Brian Steele's beard is looking nice and trim. I wonder if he uses Manscaped. That's right, boys. This video is brought to you by Manscaped.com, the global men's lifestyle brand that is revolutionizing men's grooming. When you have the confidence of 10 million men worldwide, it's pretty clear that Manscaped has produced some of the best hygiene and grooming tools for your balls. I present to you the Perfect Package 5.0, the Lawnmower 5.0 Ultra Electric Trimmer, Crop Preserver, the best ball deodorant on earth, Crop Soother, the best aftershave ball lotion on earth. I've been using this 5.0 trimmer for a few weeks now. It has dual skin safe technology. It has an upgraded trimmer blade from the previous version and an interchangeable foil blade for enhanced performance. It has a little light on it that aims perfectly at your balls. And of course it's waterproof so you can use it in the shower. I've had every previous version of this trimmer and this new trimmer blade is the best one by far. It cuts hairs with ease. It's almost like getting two trimmers but you're only paying for one. The Perfect Package also comes with the best boxer briefs on planet Earth. I've said this for years. These literally feel like you're wearing a cloud. Go to manscaped.com right now and get the Perfect Package 5.0 Ultra and get 20% off plus free shipping using my code CUFBOYS right now at manscaped.com. It's an amazing product and a great deal. 20% off free shipping. Go do it right now. Love you guys. Here's the rest of the video.
The transcript, that the court take note of the differences between what occurred in the hearing and what Mr. Steele has represented to the court. As it relates to intimidation, Mr. Steele asserts that a statement made by Ms. Hylton essentially is part of what makes the hearing improper. The state has cited in its motion or its response to the court that support the state's position that this hearing was not improper.
Why don't I just put on the record, because I've got Judge Krause's order right in front of me, exactly what it is that I think we're talking about. And I believe, and Mr. Steele, you can correct me if I'm wrong.
Mr. Whitaker just takes over sometimes. She's like, all right, let me clarify all this. I like that attitude. She's moving on. She's getting shit done, boys. Glanville would let Miss Love just talk for days on end. Like, I get there a lot of talk.
Worth noting that this court generally agrees with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Is that what we're talking about? All right.
King versus the state itself ruled after an appellate complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derivative use immunity.
She's citing King again, when in the King case, it's just about immunity. They're not fighting immunity. I'm sure one of the defense lawyers is going to point that out.
As is recorded in the transcripts of the July 10th proceedings in open court, that Mr. Copeland had questions that he was attempting to ask the prosecutor, Ms. Hylton, and the person representing Mr. Copeland would not afford him that ability while we were just outside the courtroom. And Mr. Copeland was then called in with the jury in the box without having had the opportunity to have those questions answered. Hearing in chambers, as is reflected in the transcript, dealt solely with Mr. Copeland's rights, what he faced, what his obligations were. The state's action of moving the court to compel Mr. Copeland to testify is what precipitated that chain of events that led to that hearing in chambers. And we wanted to ensure that Mr. Copeland was aware of whatever it was that he had sought to gain clarity about before he was forced to come in before the jury.
But you also, crazy that Miss Love acts like them explaining to Woody his immunity deal is all they did. But they also threatened him with years in jail. There's more to the story here, Miss Love.
Have read the transcript, and the transcript is the best evidence of what happened there. And what we're dealing with is can and or should reconsider, I guess, the factual findings made in Judge Krause's order.
So the state's position, Your Honor, is just as Judge Krause was the authority of the court tasked with making a determination regarding recusal. The court has been tasked with the responsibility, the assignment of continuing the trial. Judge Krause's responsibilities we submit to the court are Judge Krause's, not this court's.
The only thing I want to add is that the King case and the Gilbert case are about a different circumstance than we are objecting to.
See, I knew he was going to point this out. He pointed this out in that interview he did. I covered it in a previous video like a day or two ago.
That is a hearing about the issue of whether the immunity should be granted by the court. Presumably that was done in this case sometime prior to Mr. Copeland's testimony on the 7th. What we are concerned about, object to, believe violate our client's rights, is the ex parte meeting that took place in chambers on the 10th, far after that immunity decision was made. At least just speaking with respect to my client, Mr. Kendrick.
Yeah, it's styled a motion to challenge essentially Judge Krause's factual findings in her recusal order.
She's going to deny this because I see what Steele's trying to do to make it an official record that the ex parte meeting was improper, but she doesn't give a fuck.
It appears to me to ask this court to almost sit as a reviewing court and find certain factual findings to be erroneous. And this court doesn't have an ability to do that. The time to have filed or sought a certificate of immediate review has passed. I can't really sit as a reviewing court over a fellow superior court's order. I'm not going to reconsider Judge Krause's factual findings, so I am going to deny that particular particular motion. An ex parte in and of itself is not necessarily a bad thing, and both sides have appropriately held ex parte communications about things that should be ex parte with Judge Glanville prior to this. So there's nothing in any of those sealed filings that the other side needs to see at this point or that was improper.
So she's saying there's no more ex parte meetings that have been improper.
Within the transcript, there's a clear indication Judge Glanville is aware of, as Mr. Steele alluded to, questions that the state is in possession of. They seek answers from Mr. Copeland. There is nothing in the transcript that indicates a discussion between, I believe it was Ms. Hylton that was in possession of this list of questions. There's nothing in the transcript that indicates a conversation that even suggests how Judge Glanville would be aware of these questions, the existence of these questions. And it just leads me to the inescapable conclusion that either the transcript is not complete or there was a separate meeting that occurred, because there's just no context to it. It just doesn't make any sense to me logically.
All right, so I read that part of the transcript, and obviously I wasn't there, but when I read it, I just thought, I think Judge Glanville used to be a prosecutor, and he assumed surely you must have given them a list of questions. Now, I have no idea whether if it was just...
Oh, Miss Love shaking her head. Yes, that's what it is.
Or if there had been a prior conversation, and I will ask Ms. Love that.
No, Your Honor. We were very sure to only talk about what was happening, which was getting Mr. Copeland purged from his contempt. So I made it clear that we weren't going to talk about anything substantive, and to talk to the judge about any questions to me would have been substantive. So we never talked about any questions with the judge prior to Judge Glanville saying that during the meeting.
All right, and was everything that occurred in that meeting, other than the times when, was everything else recorded?
Yes, Your Honor.
I love how she says y'all, dude.
Based on that, I don't find that there was any other untranscribed prior meeting between the state and Judge Glanville.
All right, so the judge is officially saying that there was nothing outside of the record of the transcript. That's the ruling as of now.
Slights and misrepresentations by Ms. Love that I'm not going to go through in more detail. They're in the motion. I'm just going to say, Ms. Love, make sure that your representations to the court and in court are accurate and professional.
Oh, shit. She warning Miss Love.
I will continue to do that as I have now.
All right.
The court require all parties to make certain that.
Okay. All right.
I will continue to do that as I have been. Okay.
With regard to Judge Glanville's comments, I mean, he's off the case at this point. If we want to endeavor to craft some sort of a instruction to the jury, you know, I'll consider something that y'all want to present to me. I know in particular, Mr. Steele, you took issue, apparently at some point, Judge Glanville used some adjectives about you, specifically unprofessional and unprepared, that are bothersome to you, and I can understand that. I would also say that not only is that in the past, but if that was in front of the jury can see for themselves how you present, whether you're professional, whether you're prepared, and so that ought to take care of that. Still
very inappropriate for a judge to do that, but he's off the case, so her rulings so far have kind of made sense.
We get to the motion to disqualify attorneys Love and Hylton, the two of the main ADA prosecutors in this case. You assert that Judge Glanville provided legally incorrect information to Mr. Copeland. I just want to make sure I'm clear as to what you assert that legally incorrect information is.
Okay. So going back to what you've read and digested June 10th, 2024 ex parte meeting, the use immunity, as we discussed earlier, just protects Mr. Copeland. Prosecutor Hylton, and what Judge Glanville was telling Mr. Copeland, you can say lies, as long as they're not big lies, and you will not be prosecuted. He can be prosecuted for perjury and false statements.
I mean, he's not wrong. They did say that, but he can be charged. So it was a little confusing. I could see why Woody was a little confused.
But it's the judge saying you won't get in trouble. He says that throughout. You can say you don't recall. You won't get in trouble. There's also a place in here where the judge tells Mr. Copeland and Ms. Hylton that the statute of limitations, this is Ms. Hylton, the statute of limitations has run. In federal court, she says, I looked it up. In federal court, it's a 5-year statute of limitations. In Georgia, it's a 4-year statute of limitations. Your Honor, that's just not true. He's an unindicted co-conspirator in this case.
It sounds to me like they're talking about some kind of particular crime he might or might not have committed that he might be testifying about and whether has no statute of limitations. That sounded like it was a really particular crime.
Can't tell a person. I wouldn't tell a person. How about that? You can't be prosecuted because statute of limitations ran. Well, you know, he could be prosecuted in our indictment. The state is saying,
agreed.
Yeah.
That appears to me to be talking about something very particular that they've had, like a particular crime they had conversations about, and not overall broadly. You can't be prosecuted for anything.
I don't know.
Okay.
We need the audio of this transcript. There's got to be audio, right?
Is there anything else that Judge Glanville said that you believe is legally incorrect information?
Yes.
Okay, because I want you to address that.
We need you to testify. Why do we need you to testify? That Mr. Copeland had to stay in custody till all 26 criminally accused have their cases disposed of? That's not true.
Okay.
That's wrong. You can't just hold a human being in custody until all 26 people, some of them don't have lawyers. Forever. Yeah. That's what Judge Glanville said. That's the problem. So
some of the co-indictees of the other people that aren't on this trial don't even have a public defender yet because or Fulton County, I don't know, doesn't have any public defenders for them.
At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015 that you found yourself in an office with a judge? This person who I'm pointing at there, he'll say, I believe no. But the transcript says, exactly. You spoke with Ms.
I
Love
mean,
earlier.
if we get to that, that may be something that you are able to examine him about.
She's going to let him cross-examine Woody about the ex parte meeting? Frick yeah.
They also tell him how to testify. Judge Glanville tells him, the judge has stepped out of his role as a judge. What judge tells a lawyer, tell your client, whatever the words are, you make decisions, obviously, but this is how I read it. Tell your client he's going to face significant cross-examination. And you know what else? The judge goes further. The judge said that the client, he's telling Mr. Copeland that the client's guilty.
Mr. Copeland's not here at this point in time. This is his attorney, Ms. Bumpus.
All right, let me get that.
She wants to hear direct quotes of what Glanville told Woody.
But if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Why?
Well, I think because this whole thing has to do with the fact that there was a 507 immunity order granted.
But he can be prosecuted for this case.
Which is not what the judge is saying there. Okay.
I don't know. I don't know any judge who gives advice like this.
Yikes.
It might be appropriate in the context of ensuring the client understands what could get him in jail for contempt and what the grant of immunity means, that he would explain to the witness, the potential witness, here's what it means. So, all right, I don't find anything improper about that particular one.
So to me, telling a person you can say you don't know, nobody should tell a witness you don't know. That's all the state wanted. I don't recall, so they could get in prior. It's in front of the judge. And then with that was Brady, as you said, evidence. Yes, I have it now. But why wasn't I told that? And I want to ask questions.
Okay.
That's the main issue here. The defense was not told about any of this. They just walked back into court and acted like nothing happened.
Judge Glanville is off the case. That all would go to whether it's appropriate for Judge Glanville to be on this case. That has been taken care of.
My understanding of the law is the motivation for any witness to testify is admissible evidence.
Right, and you can certainly ask Mr. Copeland about that.
And I'd like to ask the judge on page 36, line 3, until the trial is over, until all defendants have been, I got these 6 that we have right now, then there's another 6. And someone said, no, there's another 12. The court said, there's another 12 or thereabouts that are still outstanding for various forms or another, and they're talking about he has to stay in jail. And I'd like to ask Ms. Hylton, Ms. Love said the same thing, and Judge Glanville, why would you tell him that when that is not the law? You can't just hold a human being.
All right, so you can certainly ask Mr. Copeland about that.
Okay.
I don't know.
Can you imagine if Glanville actually was called as a witness? That would never work. This trial is such a shit show.
Why it is you ought to be able to have Ms. Love and Ms. Hylton removed from the case.
Yeah. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. And that's not true. They can prosecute him. They can't use his word.
Okay. All right. I will take all of that into consideration. Think that I'm going to make a ruling on this particular motion today. I want a full look at all of it in context because I do think we have to consider it in context. I will note.
So she's saying in context, so she's deferring the ruling to get rid of Love and Hylton off the case. I don't think she's going to do that. I think this trial is continuing. Just her attitude and everything. She thinks everything wasn't too big of a deal. I can just tell.
By the holding of hands of Judge Glanville, Ms. Love, and Ms. Hylton, that they all intimidated, coerced, directed, encouraged, whatever the right word is, Mr. Copeland to do what they wanted him to do. It's in the transcript. We need you to testify. I'm not making them witnesses. I'd rather they stay on, to be quite frank. They made themselves witnesses.
Shit, that was a line right there.
Why would a judge say speak with the state and go around the lawyer, even in front of the lawyer? So all of this, to me, is very at the heart of that gentleman's testimony, his credibility, and it invokes and puts into effect the testimony and credibility of Ms. Love. Ms. Love, I can't ask anyone on the earth. I have a transcript, but I can't ask Mr. Copeland, why did Ms. Love tell you? Did you ever find out this statement? And if his answer is yes, because Judge Glanville said, remember, Ms. Love told you. I want to talk about that. And then at some point, I want to ask Ms. Love, why would you tell a human being that he's going to just rot in jail until 26 people are gone, which is not the law?
Coercion, witness intimidation.
And those promises were not given to us. They were hidden from us. And Judge, this did come out. Your Honor, this did come out. I got it now. I understand that.
All right, so I think this is rehashing kind of old ground that's not relevant to where we are right now.
I want to bring it all up in front of the jury, though.
Well, we'll get there when we get there.
That instruction that the judge has no role in the case except, it's not verbatim, but except to make sure that every party has a fair trial. I'm going to tell the jurors that didn't happen.
Okay, well, we'll see whether that's going to be something that is permitted argument or not if we get to that.
Jesus, Brian Steele's like, I'm going to tell the jury about all this shit.
They strongly insinuated that myself and Mr. Steele were somehow in cahoots with John Melnick and were somehow, I guess, obstructing justice, tampering with a witness, intimidating a witness. They presented the judge. And mind you, this is an ex parte meeting where I was not allowed to respond. Mr. Steele was not allowed to respond. Ms. Love said to the judge, well, Mr. Melnick sent Mr. Steele and Mr. Schardt an email. And he may have inadvertently included us, possibly by mistake, and was communicating with them that Mr. Copeland would not be testifying. And we don't know what they have going on between them, and I guess we were just lucky to be inadvertently included, CC'd. Judge, I have the email. I believe it's in the record. I can show you the email. The state's not CC'd on the email. It's to the state.
Okay.
So that was a misstatement. Convenient. There's absolutely the reality is the state was meeting with Mr. Copeland behind the back of his attorney. The reality is the defense was pristine in their duties and dealing with an attorney and not with a represented individual. And somehow the state, in this ex parte meeting where we were not allowed to respond or even to hear the accusations, suggested that the purpose of this meeting was based on this behavior by defense attorneys and Mr. Melnick, which was completely fabricated and offensive.
Everything after at least the 10th and probably the 12th needs to be redone, and that is all of Mr. Copeland's testimony, or virtually all of it.
She's going to unwind all of Woody's testimony. She's going to tell the jury to delete that out of their brain. How is that possible? We knew this was coming, but I'm just so surprised.
To instruct the jury about this, if we're going to be redoing Mr. Copeland's testimony thus far, we're probably, unless y'all decide you want to stipulate to parts of it, which you certainly can, we're going to be telling the jury to disregard it anyway. And if we're telling them to disregard it, then we don't need to talk about what might or might not have been significant in it, because we don't want them considering it. So y'all keep that in your minds as well. And that may be something we don't get to until tomorrow, but I'm going to take this particular motion under advisement.
I would need to show the jury that it's the state, and I have evidence now, and the judge, that has been the person to intimidate a witness. So that's another issue when you're resolving this.
It's not us intimidating the witness, it's the state and the judge. That's so funny. I mean, it's low-key true.
Okay, let me ask you this then. Why can't you use the transcript to get that point across? I mean, it's right there in the transcript. What it is that you assert to be intimidation is...
That's what the state said. Remember, they were like, they have other sources to do this. They don't need to call Judge Glanville or us as witnesses.
Why are you asking these other witnesses this? And what other witnesses, how do you treat other witnesses? There's another witness named Miss Bennett who said basically the same thing. She was intimidated by the state. My point is, I can't ask Mr. Copeland.
But the issue, as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland into testifying. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting between the judge and the prosecutors like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
Right.
and Mr. Copeland can't answer those questions. And
That you can argue, because you will have, look, we see that it happened here. Trial and objection to mid-trial substitution of trial judge.
This trial is completely broken. There's error in this trial that would never survive appellate review.
Appellate courts would have about 50 reasons to overturn a conviction if there is one.
Illegal ex parte hearings have occurred. Our client's rights have been repeatedly violated. The defense has been mistreated in front of the jury by a partial judge. It's broken. We are also winning this case. We are put in an impossible position right now because our rights have been violated. We do not wish to move for a mistrial. We are merely pointing out that this case is broken, and I filed a motion about that, and I will get into the reasons when it's my turn. But I am trying to be very careful to make it clear that I am not moving for a mistrial, but I have extreme doubts about the ability for this case to continue, and I am absolutely certain that my client's rights have been violated throughout this process.
Kendrick's motion for mistrial essentially asks for a mistrial with prejudice, because the assertion is that the state wanted this mistrial, goaded the defense into it, and under those circumstances, if a mistrial is granted, and those are the actual facts, that any mistrial would be with prejudice without the ability to try the case over again. The determination has to be made whether the state had the ex parte on purpose with the purpose of goading, to use Mr. Kendrick's attorney's word, the defense into making a motion for mistrial, because the state thinks they're losing the case and wants to be able to do whatever.
It's going to be hard for the judge to rule on that. Like, how is she going to rule on the state purposely doing all this? So there's a mistrial and they can do it over again. I feel like that one's going to get denied.
Tremendous experience of the prosecutors and skill of the prosecutors in the state as both, in this case, as both attorneys and prosecutors. So I cannot believe that they would not have asked for this ex parte, conducted the ex parte in the fashion that they did it, unless they knew that they would be forcing us into a position to request a mistrial. As
Defendant Kendrick's representations to the court that, and others, that they're winning, and therefore we goaded them. If they're winning, then let's just keep it rolling, because the state vehemently objects to a mistrial. Okay. In conducting something according to the rationale presented to the court by the defendant so far, that the state never intended that they find out about, in an effort to cause them to do something. I don't know how those two can be squared with one another.
Miss Love, man, Miss Love.
So deny the motions for a mistrial based on the state, based on anything. I'd point out that this is not the first or the second or the third motion for mistrial. The state has objected every step of the way.
Clear in my motion that we are arguing that there was improper conduct by both the state and the judge that violated Mr. Kendrick's rights, locked up in Rice Street for 22 months
I have done everything that I can to move this trial along. I filed a motion, I believe at the end of March or early April, to try to get this trial moving at a more deliberate pace. That motion was essentially denied. No interest in retrying this case, Your Honor. And we are winning, I think, by any measure. So I'm asking for this mistrial, but I'm doing it because I have absolutely no choice but to do that, Your Honor.
I do find that the prosecution did, in fact, oppose the characterization made by the defense and posit their own characterization. In their response, they say, quote, the hearing in chambers was proper, unquote, and then quote case law. So that to me is not the state saying, yeah, your characterization is right. That is them saying, no, we were not trying to get a mistrial here. We didn't do anything improper.
So Judge Whitaker is not buying into the whole goaded into situation here.
So that's another one that I'll probably give you my ruling tomorrow. Essentially says that there are reasons why the mid-trial substitution of another judge makes this impossible, and guarantee to everybody, to the extent that is within my control, I want for everybody here to have a fair trial under the Constitution of the state of Georgia, the United States, and the laws of our state. Okay, that is why I am here as a judge, to make sure that that happens. So to that extent, it's granted.
And the state was in a position that their key witness, and without him, the alleged murder of Donovan Thomas, without his past statements, goes away. And they were in a situation where their key witness was not taking a stand and was not going to allow himself to be impeached with prior statements. And our stance is that they panicked. They needed a mistrial. The trial was not going well. The previous witnesses that have testified has been
Pretty sure Ms. Hylton and Love just laughed.
I absolutely intend to familiarize myself with what has gone on in this trial prior to me getting involved in it. I've already begun to. Judge Glanville's court reporter is beginning the somewhat arduous task of transcribing everything that hasn't been transcribed yet and giving that to me, as soon as she finishes it.
Okay, yes, I understand that the court is going to make what I think to be an impossible effort to catch up. Thereabouts, hundreds of witnesses. I appreciate the court's effort, and I understand the genuineness of the court's statements that I'm going to do it. But you know what? I just don't think it's possible. And that is the gravamen, that's the base of what we contend should be a motion for mistrial, qua mistrial. I have joined in we've been goaded into it, but now the second layer of that is I am going to stand here. My team is going to stand here. Everybody in this courtroom is going to stand here and look at you and say, Judge, the state, I want a directed verdict of acquittal. The state has not met their burden. You can't necessarily make those kinds of judgments based upon a dry transcript.
Just on what gets presented going forward, I will be able to rule on the motion for directed verdict, assuming we get there. I can and will ask for specifics from the state as to what the facts are supporting each count of this indictment. And it is not for directed verdict whether I'm convinced, it's whether there is any evidence from which a jury might be convinced. And so we'll take that up when we get to it, but I don't think that the fact that I'm coming in mid-trial is a basis to grant a mistrial in this case.
The 13th juror thing she's bringing up is if they are found guilty, the judge has the power to overturn that if she believes so. A directed verdict of acquittal means the judge thinks the state hasn't presented enough evidence to show the defendants are guilty, so they acquit them.
Outstanding bond motions. Steele, on behalf of Mr. Williams, has filed a motion for bond reconsideration, but Mr. Steele, you essentially go back and argue anew all of the took up the bond to begin with, but another court has already considered all of those, the Ayala factors, and you don't present changed circumstances. You just essentially say this call was wrong to begin with and you should do it over, and I am not going to reconsider any bond issues that have already been considered and ruled upon by another court, legitimate changed circumstances. So that motion is denied.
Reason to believe that Mr. Williams is fleeing. He would be crazy, because if he flees, the case goes on because it's mid-trial, and he waives his appellate rights. He has the strongest ties to the community.
That's a good point. It literally makes no sense for Thug to flee if he gets bond. This conviction, no matter what's getting overturned. That's what I think, and I think a lot of lawyers would say that as well.
Wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. They are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally. That's not before me. Those are not the kind of changed circumstances, so I'm not going to reconsider the bond.
So she's denying Thug's bond. Unfortunate. I don't really agree with that at all.
And I'd like you to address just one last thing. That judge and district attorneys come out after the ex parte hearing and not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, the same judge hiding Brady evidence. So I'd like you to consider that.
All right. Thank you. I understand.
And Mr. Copeland tells the police is trying to find his friend Demekion Garland and trying to figure out where his friends are because he woke up in the middle of the afternoon. And he allegedly calls Mr. Garlington and travels down to a McDonald's on Cleveland Avenue. In pretrial statements, he says Mr. Garlington and a gentleman named Mr. Demise McMullen who's also known as Nard, and is also charged. Mr. Garlington gets in first and quickly indicates to Mr. Copeland, before outside of the earshot of Mr. McMullen, they killed Nutt.
The spill the beans statement, he says it's not hearsay and it can't come in as a co-conspirator statement.
There's been no allegations whatsoever by the state. In fact, we've been talking about this ex parte motion ex parte hearing where they're saying that Mr. Copeland clearly had nothing to do with the murder of Donovan Thomas. Kenneth Copeland had nothing to do with that conspiracy. There's no evidence of anyone soliciting his membership in the conspiracy to murder Donovan Thomas. If the argument is, well, they were trying to solicit his membership into a larger conspiracy. Mr. Copeland, according to the state, they've shown the jurors pictures of Mr. Copeland, videos of Mr. Copeland from 2012, 2011, 2013, well before this date, where he's with these gentlemen, putting up hand signs, claiming YSL, all the rest. If the argument is, well, they were soliciting him into the larger conspiracy, he was already part of the larger conspiracy, according to the state.
Another concept was to further the purposes of cohesion amongst, and I think they have gang cases, so a gang.
Allegedly, Mr. Garlington made to Mr. Copeland. So there's absolutely, the record is just completely devoid of any evidence that supports that other than the statement themselves and just reading into the statement, assuming, well, it must have been done for cohesion. But again, if we can just assume with nothing else, then what's the point of the rule to begin with? Mr. Copeland has never testified that anyone allegedly involved in the murder of Donovan Thomas has ever asked him to do anything.
The state is basically saying that these statements further the conspiracy of YSL, Demikian or Scarface telling Woody that they just killed Nutt. And if the judge finds that it does further the conspiracy, then she's going to let it in.
According to Mr. Copeland, they were the three best friends. So I don't understand how that falls under fostering cohesiveness, because there was already extreme cohesion between that group. There's no indication that Mr. Copeland needed to be kept up abreast of the developments at the time.
Miss Love has been making so many faces. Look at her face right now.
A statement merely spilling the beans, disclosing the scheme, or informing the listener of the declarant's activities are not a statement in furtherance of the conspiracy.
So that's a good case for him to cite that. Spilling the beans statements aren't furthering the conspiracy like Scarface said to Woody.
Self-exculpatory statements are exactly the ones which people are most likely to make when they are false, and mere proximity to other self-inculpatory statements does not increase the plausibility of the self-exculpatory statements. And for the record, that's
another good point right there about self-inculpatory statements.
When Demikian Garlington alerted Kenneth Copeland that they just killed Nutt, he was alerting Kenneth Copeland to the fact that a high-ranking rival gang member has just been killed by our guys. And it's important for us to now prepare, protect ourselves, and flee to Miami.
A lot of this is not, and I put it right in, I'm objecting to any proffer of Ms. Love. A lot of this is her theory. It is not what the evidence has shown.
That's a good point. A lot of that was their theory. There isn't much evidence besides what Woody says.
When we're using the word fled, is that Mr. Williams had a show in Miami.
We're using the word fled to Miami, but actually Young Thug just had a performance to go to in Miami.
Was there a show for Mr. Williams down there? Some kind of a music show, I assume?
That's the assertion.
Okay.
That's their assertion. All right. So can we show proof of a show in Miami, please?
All right. So back in the Atlanta area, there is a series of retaliatory shootings. Is that in evidence, or is it going to be
that
evidence?
Has been already put in evidence,
okay,
and additional information regarding those.
And is there any evidence that Mr. Copeland was involved in any of those shootings?
Yes.
Back and forth. Okay.
And alerting Mr. Copeland to what just took place. It furthers cohesiveness. It lets him know about a significant event that just took place that involves members of the gang itself that he needs to be aware of. He needs to be alerted to so that he can act accordingly. Mr. Garlington, as we said, is providing information about, we argue, a gang-motivated crime committed by members of the same gang that he is a member of. In saying what he did, he is talking about actions committed by, I would argue, co-conspirators. He's a member of the same criminal conspiracy as those that he's called murderers and shooters in the Lil Wayne incident. He is, given the context of his relationship, his being Garlington's relationship with Stillwell and the other YSL associates that he names as having killed Mr. Thomas, he had no reason to lie about the murder. He would not be privy to the information that they just killed Nutt had he not been a part of that same gang that these persons that he alleged have just killed Nutt. And Your Honor, the fact that Mr. Garlington is alleged to have been, according to the statement, with them when they drove by and saw Mr. Thomas before the murder.
Okay.
Also reflects his involvement in the gang itself.
Okay.
Whether they're in furtherance, you asked, was he directed? The answer is no. He called Mr. Garlington. Mr. Garlington said, hey, and this is before making any statements. Can you come pick me up? A statement, we say it was never made. Mr. Copeland now says it was never made. But regardless, the statement, if it was made once Mr. Copeland gets down there. He's never directed to do anything. He just goes and follows people that he knows. The state is saying so he could comport himself appropriately. They have no evidence of that at all. That's just their theory, and it's just a blanket statement to say that it fits under these cases, but it's not backed up by anything.
All right, so there's Max Schar's response. I think she's going to let these statements in.
And again, I don't know whether this is styled for reconsideration or what, but it's an issue we're going to have to deal with going forward. So while I'm not reconsidering prior rulings, we do have to sort out how we're going to handle this moving forward, and that is concerning 801 and self-serving statements.
What was happening is anything said by Mr. Williams that I tried to get in on cross-examination.
So what Steele's arguing here, the state brings in Thug's lyrics and snippets of his lyrics, but they don't provide the full song, obviously. Brian Steele actually wants to show the full song and some of the performances on music videos for context. State obviously objects, saying this is self-serving.
With an objection that was sustained as self-serving statements. At times, the recused Judge Glanville would allow it in under the rule of completeness, so 106. Under the old rule, self-serving statement has to go to innocence. That's why it's self-serving. But anyway, I'm not saying that it's ever going to come up, but it happened so frequently. I just wanted to be courteous because that's the way it was going for several months in the court.
You know, I looked at all your case law and I've looked at the statute, and I agree that there is not that's really no longer the issue. If something is going to be excluded, it's not going to be on the basis that it's self-serving. It's going to be on the basis that it's hearsay and there's no recognized codified exception that has been met. And like I say, we'll take up the specifics as they come at us.
So she's basically deferring it, saying it's case-by-case basis.
My recollection is Miss Love indicated on January 10, 2015, Mr. Thomas was just hanging out, on the street with his good friends, having a good time and, just having a friendly time. And then these mean guys did this thing to him, which was misleading. But then the state presented witnesses that said that Mr. Thomas was a gang member. This wasn't us. We didn't bring this up. That he is a gang member, that he was a gang leader. And then they brought in experts that talked about If Gang, Inglewood Family Gang, and Bird Gang. And these are the gangs that Mr. Thomas was associated with. And so all this character evidence has really come from the state's witnesses and it's been elicited by the state. Our stance is that Mr. Copeland on the stand, and assuming he testifies consistent, would not deny making those statements. So I don't even know why we're playing prior statements to begin with.
Because he's saying they're not inconsistent statements.
In general, Your Honor, the defense is not, we haven't been bringing out evidence about Mr. Thomas. The state played a video where Mr. Thomas's brother was carrying an assault weapon in a barbershop at the time of the shooting.
The state doesn't want the defense to bring in bad character evidence of Donovan Thomas, but they haven't done that yet. And he pointed out that the state actually showed a video of his own brother carrying a goddamn Draco the day he was shot in the barbershop. So now I believe they're talking about Miss Love's motion where she's asking the judge to make Thug's team hand over all evidence.
So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell. And then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
Yikes.
Solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
You wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
all right.
I made, and then when I amended it.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes. Okay. Yes, I was not saying that.
She completely botched that. That is basically what she was saying.
My apologies to the court for that inartful wording. The defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is, yes.
Okay.
We have one recording of witness Adrian Bean that apparently was made on an iPhone, but is, according to the information that the state received from the witness as he got off the stand, that may not reflect all of what was taken down. And actually on the stand, he instructed Mr. Steele to keep it 100, implying that that's not everything. In other words, that what we were hearing was not everything. The recording itself was kind of degraded, and we were not, it did not appear to be one pulled directly off an iPhone the way that an iPhone would, the quality of an iPhone recording would be. And I apologize to the court. There was one more instance. D'Angelo White was a witness that the state put on the stand, who represented to the state that that counsel for defendant Williams recorded the interview, or appeared to be recording the interview that he conducted with D'Angelo White at the Fulton County Jail. We've never received any recording of an interview between counsel for defendant Williams or anybody else conducted at Fulton County Jail. I believe I heard earlier reference today to...
He already has been examined and cross-examined?
Yes.
Okay, and no such recording was used?
Right. They didn't.
Okay, then why would y'all be entitled to it?
It's just an example of something that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every aspect of a defendant's case. You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not.
The court is correct.
Okay, so that one doesn't matter. Okay. Unless anybody wants to say anything else, I'm just at this point going to say I expect y'all to abide by your discovery obligations.
And Your Honor, if I may add one more thing, I believe that counsel for defendant Williams emphatically stated he does intend to use a video recording that he has in his possession of the witness currently on the stand purportedly saying what he asserted, and that
Okay, well, I mean, I can see how that might be impeachment evidence, and I'll have to hear whether and how it might be substantive evidence. Mr. Steele.
Miss Love's not happy about Brian Steele having a video of Woody that he wants to use that she doesn't have yet.
So I believe that what the state has asked you to do and what you said from the bench about the law that will apply in this case is not accurate under Georgia law. I have all objections to any proffer made by District Attorney Love. They are not only wrong, I'm going to show you why they are knowingly wrong. This is the fourth time we're having the same hearing. I know you're not here privy to this. Okay. Prosecutor Love did not tell you. It's the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Glanville already ruled on this, so you got to take your L, Miss Love. Like, she never takes her L's. She's trying to do this a 4th time. So Brian Steele is pissed off here, and he should be pissed.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Miss Love intentionally, I assume, she has a memory of this because she was here. I hand her all these cases. I assume she's doing it intentionally. First of all, this broad term does not mean that the term case in chief does as well. Indicated that a party's case in chief encompasses the time in which a party calls its first witness until it rests by repeatedly using the term case in chief in that. There has been 0. Georgia has never cited Weibel or Young in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. My point is, case in chief it's a term of art.
It has a distinct meaning.
Yes. All the U.S. Supreme Court cases, courts have repeatedly used the term case in chief to refer to the part of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
that's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to get it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigator, she can call me, give me any recordings that you have of Mr. Bean, the investigator's skill. So he must have said, I wasn't on the phone. But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't have given me anything. This is so wrong of the prosecution. 4 times I've given the same case. 4 times I gave that green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting, I am never taking Ms. Love's proffer. Okay, so she says that I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her. But that I
said... Is there somebody on the state's case that you are able to talk to?
Yeah, Ms. Willis.
All right. Well, okay.
Miss Love and Brian Steele's beef is crazy.
Has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts we killed Nutt, referring to Donovan Thomas. Well, let me tell you how that happened. I never said that. Ms. Hylton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a social media recording that he killed Nutt, or we killed Nutt. It's in writing. Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say. I never said, I verbally asserted that I have anything. But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hylton, did you kill Nutt? And he said no. That would be impeachment. Did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth. October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness. They want me to tell them which jail calls am I going to use to impeach the man. I said I'm not going to do it. Judge Glanville said you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this. And then to stand here and say I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he was on the witness stand. It would not shock me.
Brian Steele's so pissed.
He was there for 3-4 days. All he said was, I don't recall. That's what he said. I don't recall. Did you say this? I don't recall. I don't recall. So the state got in his prior statements to detective. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt, I have no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Miss Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected, outrageous, outrageous. It just flows right through. The same way Miss Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it. Because she sat here in court and I did the same thing without being tempered.
Right. Georgia law does not define. It does not define case in chief. It does not break it down.
We all know what a case in chief is. Don't we? I think we all know what a case in chief is. Do you have any case law
in Georgia
that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence? That's my question to you.
Ms. Love will not answer that question. Come on.
And in the motion itself, we have not ever presented or represented to the court that there was a Georgia case that addressed this issue. And the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Yeah, I'm representing that. That was the position that was taken. That was what was analyzed in the cases that we have cited in our amended.
Judge is not happy. How is there lacking clarity?
They have a duty to disclose it. And that is the origin of the state. That is the basis for our position.
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before. So
I don't mean in writing. Y'all have not had any discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted. I've never made this distinction. I've never said that that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that. I've never made that argument in a written or oral filing.
Okay. I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Love.
Respectfully, I take it very seriously.
Oh no. Judge and Miss Love not getting along already.
Anyway, we'll be abiding by the discovery requirements set forth in our statutes. And Mr. Steele, thank you for the clarification.
Yikes.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial and still being in any way efficient with the jury's time? You're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And I'm not going to say I need you to know everything tomorrow because I know it's a voluminous case, but y'all been putting this case together for 2 years. A whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months, which ought to be, frankly, the end of this trial by then. I mean, it should not take another 7 months. It shouldn't.
Jesus. This judge is so pissed at how slow the trial's been going. I'm loving this. I hope she speed this up. All right, that's pretty much it for today. A lot of motions. I just recorded here for 5 hours, so I don't know how the hell I'm going to edit this down to anything less than like 40 minutes or something, dude. I don't know how long this video is. Probably extremely long. Hey, subscribe, join the channel membership. It's only 10 cents per day. Love you guys. Thanks for support. Peace out.